Our next case is People versus Neely.
Thank you, Your Honor.
Thank you. Good morning. This is a 15-minute mini oral argument on the application. You can hold on until you're ready. Wasn't trying to rush you. You may reserve time for rebuttal, but we ask that you keep track of that time on your own, and you may begin whenever you are ready.
Thank you. May it please the court, my name is Claire Ward. I'm here today on behalf of William Neely. With me at council table is Jessica Zimbelman. William Neely was subjected to ex post facto punishment when restitution was imposed for the first time at his 2021 resentencing, 28 years after his offense and the original sentencing. Restitution is punishment because the plain language of the statutes says that it is part of the penalty. It is imposed at sentencing, and if you don't pay it, you get locked up. We are asking the court to vacate the restitution order imposed in 2021, and we're asking for a rule that restitution cannot be added for the first time at resentencing when it was never previously requested or ordered. I know that the court likely has some questions for me, so I will waive the remainder of my free fire time.
Counsel, good morning.
Good morning.
The question I have is that isn't this directly to pay for funeral expenses? I mean, basically, I'm trying to understand how is it punishment when it's very specific for the funeral expenses?
So in this case, the victim's family's request for restitution was for funeral expenses. But in this case, it was punishment because it was imposed almost 30 years after the crime had taken place, and Mr. Neely had never previously known that such a request might be coming because it had not been requested previously when he was originally sentenced. So there was kind of a notice problem, right? He had no notice that there would be a restitution request at his resentencing. And of course, at his original sentencing hearing, he had co-defendants. His co-defendants would have also been subject to any order of restitution. His co-defendants were adults, so he was the only one of his co-defendants who was subject to resentencing in 2021 under the juvenile lifer laws, which had changed in the meantime.
Can you explain to me why the remedy that you seek, which is vacating the restitution order, is the proper remedy and not a remand to sort of recalculate the restitution under the statute that was in effect at the time of the original conviction? Yes.
So going back to the 1993 statute wouldn't be sufficient here because restitution was added at the 2021 resentencing. There had never previously been an order of restitution. So Mr. Neely, again with this notice issue, he was in a position where for the first time at his resentencing, when he was before the court for a change to his prison sentence, because his prison sentence had been found to be unconstitutional, right? Mandatory life without parole for children is unconstitutional. So he's back before the court for resentencing as to that prison sentence. And now for the first time, there's a request for restitution, and it's mandatory under the current version of the statute. But even under the 1993 version of the statute, that request for restitution was coming in 28 years later. And so going back in time to that 1993 statute wouldn't have been sufficient to protect Mr. Neely in that case from ex post facto punishment of however much restitution the court might have, in its discretion, imposed under the 1993 statute. Again, because his co-defendants weren't there for resentencing and because it was coming 28 years late.
And while I understand that the particular facts of this case and the fact that imposing restitution that's joint and several at this point is can't be effectuated, right, for all the reasons that we're talking that you've highlighted. But can we get back to sort of the initial question of all of that sort of and what the remedy is an interesting question if it's punishment. And we have to first determine whether or not it's punishment. And I recognize the position that, some of the language of the statute is such, but maybe you could direct your argument of why it is punishment, even if it's sort of, I think most people could agree it's pretty close to the line, right? So why does it fall on the one side of punishment in your opinion?
So the punishing effects here, I think, are what make this a punishment for Mr. Neely and what make restitution a punishment. It's because you can go to prison. It's because if you don't pay your restitution, you're going to be locked up. And that threat of imprisonment is, of course, particular to the criminal law. That can't happen.
You could go to prison, right? I mean, there is an ability for a judge to determine that you didn't have an ability to pay, or that there were circumstances such that even though you didn't pay it. So it's not a black and white rule, right? That you go to prison if you don't pay the restitution.
So the ability to pay analysis coming at the time of the revocation hearing
Right.
is a difference between the current version of the statute and the 1993 version of the statute. And that ability to pay analysis coming at the time of revocation means that you're already being found to have violated the terms of your parole by not paying restitution. And now they're saying, well, could you really have paid something more? Do you have an ability to pay? But in 1993, that version of the statute, they would have done that ability to pay analysis before the restitution was even imposed. So the court would have considered, if restitution had been requested in 1993, would have considered the fact that Mr. Neely was a child. He was 17 years old. He had no high school diploma. He had no work history. He had no assets.
But that gets me back to the argument of why aren't you seeking that as the remedy? If you're saying there's this material distinction between that ability to pay analysis being at the end of the process as opposed to the beginning, why are you not seeking that process?
Because Mr. Neely hasn't had these last 28 years to be paying his restitution, right? If restitution had been requested and ordered in 1993, he and his co-defendants would have been paying it for the last 30 years. But because it wasn't requested or ordered, they didn't have that opportunity to make those payments, and Mr. Neely didn't have the opportunity to have his co-defendants jointly and severally liable for those restitution requests. So the 1993 statute just doesn't bring him back into the same position, and so it doesn't fully fix the violation which has occurred here.
Counsel, I'm, like Justice Kavanaugh noted, I find this to be an incredibly close issue. I think there are compelling arguments on both sides that it's just restitution, it's punishment. It seems like it sort of depends. And given that the judges have such discretion, I'm just sort of wondering, does it matter? Because could it be punishment in one case, but not in another?
Well,
Especially with like the 3 times, I mean, obviously, the fact that punishment can be made 3 times the amount or a restitution can be made 3 times the amount, that sounds like punishment to me.
yes.
But that didn't happen here.
That was not requested here. The rule that we're asking for is only that restitution can't be added at a resentencing when it has never previously been requested or ordered. So we don't think that this is a problem which is likely to arise all that often, because since 1994, restitution has been mandatory. So in every case since 1994, the court has to impose restitution, full restitution. And so we just don't think this is very likely to occur in many cases. But in Mr. Neely's case, which occurred in 1993, he wasn't requested, it wasn't ordered. The court could have inquired if there was a request for restitution, and could have, even if there was no request at that time, said, if there's any amount of restitution, restitution shall be paid in full, and we can have a restitution hearing as to the amount. That didn't happen, and that's why it's punishing in this case.
Thank you.
If there are no further questions at this time, I would save the rest of my time for rebuttal.
Thank you.
Good morning, Court. Heather Bergman, Assistant Prosecuting Attorney, appearing on behalf of the people. This court unanimously decided in People v. Grant that restitution is compensatory. Quoting portions of its decision from 2 years prior in Peters, where again, although there was a dissenting opinion in that case with 2 justices, the justices again were unanimous on the issue that restitution was compensatory and not punitive. The Grant Court specifically held that the compensatory nature of restitution is specifically designed to allow crime victims to recoup losses suffered as a result of criminal conduct. And then looking specifically at the legislative analysis, the Grant Court indicated that when the Crime Victims' Rights Act was passed, that it was passed in an attempt to address public concerns regarding the disproportionate treatment of victims of crime and recognizing their needs and rights. Again, demonstrating a remedial rather than a punitive purpose. The Grant Court also held that restitution, although it implies a penalty, that the line between penal and that which is compensatory is not always clear, an issue that the justices here have raised. However, the legislative enactment, again, looking at the legislative history and the legislative intent, requires that a defendant simply return victims to something resembling their pre-crime status. And the court went on to indicate that this starkly contrasts with the policy factors of rehabilitation, deterrence, protection of society, and punishment, all general foundations of our traditional criminal sentences. The Grant decision is not an outlier. For years, both this court and the Court of Appeals have cited favorably to the Grant
Counsel,
decision.
good morning. How do you respond to the fact that this defendant was the only one that is being required to pay restitution and the others are not?
Your Honor, I don't think that that factors in at all to specifically the test that this court has set forth to determine whether a law is punishment. Whether one defendant has to pay something and another defendant does not, it doesn't make it punishment. Nowhere in no case does that say that that renders an act from a compensatory nature to punishment. Many times there's not even a co-defendant that's convicted or charged. So to say that one defendant isn't responsible for restitution simply because a co-defendant may not be, that doesn't translate a law into a punitive nature.
Okay, thank you.
Counsel, can you help me? So I understand your argument to say that if you look at the intent and the legislative history and the purpose behind restitution is to compensate, that it's compensatory and not punitive. And even if I accept all of that to be true, how do we get to that when our first task is to look at the language of the statute, right? Where it says, in addition to or in lieu of any other penalty, or in addition to any other penalty required by law, how do we get past the statutory language that seems, which would be the clearest expression of what the legislature intended, that it is a punishment, even if some of like the intent or the effects or some of the other things that we might look at, if it's unclear on the face, might lead us to find that it's compensatory. How do we get to that analysis?
Your Honor, to be completely honest, if we were on the other side, of course, the people would be arguing statutory language, clear intent of the legislature. But I think that when you're looking at that clause, I think that it can simply be interpreted as well to mean that it was something in addition to. I don't necessarily think that it's necessary that we look at that language and say that the legislature meant to say that they were all one of the same kind, to say that restitution is punishment. It was looking at it as certainly a portion of the a portion of the sentence. And sentence is typically deemed punishment. I don't believe, though, that clause that the legislature used, especially in light of the legislative analysis, where there's clear indication that the purpose of restitution was not to punish the defendant.
We would have to ignore the word other.
Would have, or yes, or any
Twice.
Other, yes.
Okay.
I think that there would be good reason to do that based on the legislative history and how this court itself has interpreted the restitution statute and restitution in general. And what I was saying is Grant is not an outlier, and I think that nothing has changed since Grant. Significantly, Grant was decided after 1993, when the statute was amended to make restitution mandatory, Grant was also decided after, in 1997, when the statute was again changed to remove the consideration of the defendant's ability to pay. So the fact that nothing has changed since Grant, the people would respectfully argue that when you are respecting the rule of stare decisis, nothing should change. There's no reason for this court now, today, to say that restitution now is all of a sudden punitive in nature. And when looking at the Betts two-step inquiry, I think that and I'm not going to belabor the point that I've argued in my brief, in what I've just said, it's clearly, the people's position is it's clearly compensatory and not punitive. That's the first step. In looking specifically at whether restitution has been historically been deemed or regarded as punishment, you really think about, when you look at a sentence, what is the prime purpose of a sentence? And this court has been very active on this very issue, proportionality. Is restitution required to be proportionate to the crime, the offense, or the offender? It's not. In fact, you can have a heinous murder with a habitual offender and absolutely no restitution. Or you could have a larceny in a building and you could have hundreds, thousands of dollars of restitution. So restitution does not depend on the offense and the offender. It only relates to the victim's loss. One very big reason why it's not punitive. The other thing too, when you're looking at the rational connection to the non-punitive purpose, these are the Mendoza factors. And again, the defense bears the burden to show by clearest proof that there is a punitive, even if it looks like it's not punitive, it is in fact applied punitively. There's certainly a rational connection. You're looking at whether we're protecting crime victims from financial loss. And again, it contrasts the traditional aims of punishment. And we're talking about, the question was asked of opposing counsel, well, what about the restraint? What is it about restitution that is a penalty necessarily? And the reference was made, well, you can be incarcerated if you don't pay. We're looking at the payment itself. So is that to say then bond is a punishment? Because you can violate bond and be incarcerated if you violate bond, but bond isn't a punishment. Bond comes before a conviction is even entered. So the fact that you can ultimately be incarcerated, which I don't believe happens very often. I've been doing this for quite a while, and I don't even know that I've seen a case where a defendant has been incarcerated for not paying restitution. And again, you're looking at the payment itself. Does the payment itself create some kind of major restraint or restriction? And it doesn't. It's simply returning the victim to their pre-crime status. Defendant is giving back what he or she took. It's not punishment. And again, too, looking at if the court were to determine that it was punishment, you still have to answer the question, was this an increase for this defendant? He's arguing that as applied to him, this was an increase in my punishment. And the Luth court decided that very issue. Restitution is, the intent of restitution is to give full and complete compensation to the victim. The Luth court indicated that this doesn't increase the defendant's burden. It actually basically says, when you look at ability to pay, are we going to take away what he is obligated to pay? And I would argue that if in fact the circuit court judge at the time of resentencing had to consider the defendant's ability to pay in this case, I don't think the defendant can argue that restitution wouldn't have been ordered. We're looking at less than $15,000 here. At the time of resentencing, the defendant was 44 years old. He was resentenced to a term of 35 to 60 years. He was given credit for 26 and a half years with good time credit options. He could be paroled very soon. And when we were at the Miller hearing, there was a lot of evidence that was presented regarding the defendant's work history while he was in prison, and also his achievements. And in his comprehensive reentry plan, it revealed employment options upon release. $15,000 for a 44, perhaps even into early 50s, that's not inconceivable that he wouldn't have an ability to pay this off. Restitution orders are perpetual. They're valid, just like a civil judgment. Again, something I think that supports the idea that it's compensatory rather than punitive. And the ability to pay doesn't mean immediately. That doesn't mean simply because I'm in prison I don't have an ability to pay. If you look at language in the Grant decision specifically, the court looks at whether the defendant has or will have the financial ability to pay restitution. And also, they look at, there's language that indicates that not only looking at the existing financial resources of a defendant, but also his ability or her ability to earn. So to argue, for this particular defendant to argue this is punishment and it has been increased for me, I don't think that he can validly argue that in this case, because I don't think he can show that had the court in this instance been required to consider his ability to pay, that a zero restitution order would have been entered. And the fact, too, to say that, well, it's increased because back in 1993 I didn't get any restitution, and now in 2021 I'm looking at $15,000. When you are resentenced, you go back to a pre-sentence posture, and there's a whole host of cases that talk about that. So if that's what this court would deem unfair, then you're going to be overturning a bunch of that case law as well. And then there's the argument, well, I didn't ask for resentencing. I'm a juvenile lifer. The law, established my resentencing. Well, then we look at the idea or the fact that the statute for resentencing doesn't exclude the possibility of restitution. And when you look at the Crime Victims' Rights Act and the statute, or the Constitution that allows the victim or gives the rights to the victim to be compensated, I think that that's definitely a valid option when you're resentenced, that restitution is fair game. We would ask the court to actually deny the application. Any questions?
Thank you.
Thank you.
Thank you. A couple points to make briefly, and I did just want to point out that Mr. Neely is present in the audience. He has been paroled. And Mr. Neely was paroled with the obligation that he make these restitution payments as part of his parole. He's had to accept a job which pays $10 an hour because he needs a felony-friendly employer who will allow him time off to go see his parole agent. So he's accepted a job at $10 an hour when he could make $15, $16 an hour at Culver's. So he's in a continuing situation here where the restitution is continuing to impose a substantial burden on him, and the fact that he's on parole and required to make restitution payments will be something that he could be locked up for if he doesn't make those payments. But I wanted to get back to this question about the statute, and the statute stating that restitution is a penalty. So Justice Kavanaugh pointed this out, and in this court's opinion in Cole, the court was looking at lifetime electronic monitoring. And in Cole, the court looked at that statute and saw that that statute said that lifetime electronic monitoring was part of the penalty. And on the basis of that language in Cole, this court said, therefore, lifetime electronic monitoring is punishment. And that wasn't an ex post facto case, that was a due process case. But the analysis is the same. And Earl also relied on Cole for that distinction about the statutory language.
But didn't Cole and Earl also say that this inquiry is holistic? I mean, in Cole, mandatory lifetime electronic monitoring was included in the penalty section of CSC 1 and C2. The LEM provision said that the court shall sentence the defendant to LEM. I mean, so there are some differences in both Cole and in Earl, this court was looking sort of at the holistic picture, which I think is your opposing counsel's argument that you know, you're looking at the statutory language, but you're also looking at the holistic picture. And some of those in Cole weighed towards finding LEM as punishment, but here the argument is that it weighs the other way.
And we don't dispute that a statute can be both compensatory and punitive, right? I think it's clear that restitution, which is intended to return the victim to the state that they were in before the offense occurred, is compensatory. Just because it's compensatory doesn't mean that it's not punitive. And the punitive effects here are, of course, what we've been discussing this whole time, but they are different than they would have been if Mr. Neely had had restitution imposed in 1993. He's a person coming out of prison after 28, 30 years of making pennies on the dollar.
So are you asking us to look at the statute, and there's a difference between when Mr. Neely was first sentenced, and it wouldn't have been punitive then, but at resentencing, it is punitive. So is it a case-by-case basis?
I don't think it's a case-by-case basis. I think it's simply the rule that we're asking for is when there hasn't been a previous request or order for restitution, you can't add it on at a resentencing. And a lot of the case law, almost all of the case law, is about cases where, for instance, a statute changed between the time of the offense and the time of an original sentencing. And then they're looking at, okay, does restitution have to be discretionary or does it have to be mandatory? Which version of the statute do we apply? We are not in that situation. We are in a situation where no restitution was requested or ordered almost 30 years ago. And so to impose it now is punishment, makes the restitution an additional punishment on top of the imprisonment, which was the basis for the resentencing in the first place. So I did just want to talk briefly about Peters as well in the Mendoza-Martinez test. In Peters, Mr. Peters stipulated to the amount of restitution. So I think Peters is an entirely different situation. And Mr. Peters stipulated to that amount of restitution because one of the promises for his stipulation was that there would not be a federal RICO charge brought against him. So he was gaining something by his agreement to pay restitution in that case. So we're just really in a totally different situation with someone who's coming back to court at resentencing, subject to a new prison sentence because their previous prison sentence was unconstitutional, and for the first time having $15,000 in restitution added almost 30 years after the fact. If there's no further questions, we just ask that the restitution order be vacated, and we would rest on our briefs. Thank you.
Thank you. Thank you both. The case will be submitted.